stand out. Because we understand there's nothing quite as empowering as knowing the room is silent.
Once again, ladies and gentlemen, hope you got a chance to go and download the app and gone through the various programs and evaluated the speakers as well. Okay, and don't forget this afternoon we have the final.
I wanted to talk about the recent case that was decided by the High Court, and that is the matter before the Data Bureau Limited, who was the applicant. Between Data Bureau is the first applicant, the only applicant, and the first respondent was FIRCA, second respondent and third respondents were the Minister of Finance and the Attorney General. This relates to the new law that had been put in place when the announcement was made regarding the reduction in VAT from 15% to 9%. We are probably the only one of the very few countries in the world that has the notoriety of reducing VAT now. Most countries actually increase VAT. But given various business practices in Fiji, where, for example, we had reduced duty and tariffs on various other products previously, but we did not see that being passed on to the consumers. We were very mindful of that experience, and therefore we had put in place a law that allowed or made it an offense for a business or anybody selling a particular product or service, for them, if they did not pass down that VAT reduction, then it was an offense. And that came by way of the strict liability provisions, which essentially means that if you did do it, then you actually have committed the offense without it having to be proved in a court of law. For example, strict liability, if I can put it simply, in this particular instance, Data Bureau had provided service, but post 1 January, or post the 1 January when it came into effect, they did not pass on that VAT reduction. So they had their service fee, they added on 15%, and that's what the customer was asked to pay. But in fact, they should have added 9% because the VAT had been reduced. And Data Bureau actually admitted to FIRCA that they actually had not passed on the particular reduction in the VAT. So that simply becomes what you call a strict liability, and therefore FIRCA, as provided for under the regulations, issued a fine, a penalty notice of $25,000. Just for your information, there are about 32 companies that have been issued penalty notices, and I think all of them have paid, except for this one, or there are two others? Two others have not paid. All the others have paid. So in other words, out of the 32, 29 have paid. And those penalties range up to $50,000, and all of them have paid of the 29. Data Bureau, interestingly, actually took this matter. They did not pay the penalty. They actually took the matter to the High Court of Fiji, arguing that there was a constitutional breach of their rights. And they relied on Section 14 of the Constitution, which talks about the rights of accused persons. And in particular, subsection 2 of 14 says, every person charged with an offense has the right to be presumed innocent until proven guilty according to law. And the other provision that they relied upon was Section 15, which was every person charged with an offense has the right to a fair trial before a court of law. All of this rests here, ladies and gentlemen. This is a very important document. You must all have a copy. It's free, so you don't have to pay for it. I know you're concerned about costs. It's free. Come to the Attorney Generals. We give it by the dozens. The reason why it is very important for you, because as accountants or as owners of your own businesses or partners in your law firms, you must understand now that the Bill of Rights, unlike the previous constitutions in Fiji, has what they call a horizontal application of the Bill of Rights. It no longer is simply a vertical application of rights. What that means is that previously you could only enforce your rights against the state, against the government. Now it's not only against the government, but you can enforce these rights in the private sector too. So in this particular instance, you have somebody trying to enforce rights which they believe were their rights against the state. You know, FERCA is a representative, it's a state institution, and they also had the Attorney General and Minister of Finance, so it's against the state. But you could equally have a constitutional provision redress against a private sector organization. So you could actually apply it to clubs and societies. You can have a private company saying, or individual against a private company themselves. So you could have an employee of yours saying there's been a constitutional breach of their rights. So this is what we mean by horizontal application of rights. It's quite unique. It's quite groundbreaking. It's very forward-looking, and it is a real commitment to adhering to the fundamental rights that exist universally. But as you know, that many countries, whilst they talk a lot, they don't actually put it in practice. We do. Australia, for example, does not have a Bill of Rights in their constitution. We do. New Zealand does not have a constitution, or written constitution, I should say. But there's various mechanisms as to how people put in the Bill of Rights. So New Zealand, for example, has a Bill of Rights Act. We actually have a Bill of Rights within the Constitution. And what I think is very important, which I wanted to also talk to you about later on, is that for the first time in Fiji's history, we also have a Bill of Rights that includes not only what we call civil and political rights, which is, your right to fair trial, your right to be able to participate as a voter, etc., but also your right to socioeconomic rights, right to housing, right to access to drinkable water, right to basic health services, right to economic participation, access to transportation. All of these are what we call socioeconomic rights, environmental rights, rights of disabled persons, rights of children. This is a very extensive approach, and one of the reasons, of course, it has been enshrined in the Constitution is because we can see that many of the problems in Fiji were in fact socioeconomic issues. Accessibility to basic services, accessibility to transportation. But unfortunately, when those socioeconomic rights aren't addressed, they manifest themselves in political disruptions. They manifest themselves in people viewing it from a political spectrum as opposed to addressing the fundamental issue itself. That's another topic of conversation. So the Data Bureau actually went to the High Court and said, look, because these FERCA, terrible people, have issued me with a penalty notice, and I have to pay this penalty, therefore I'm not getting a right to a fair trial. But what the High Court said was that the malice that the actual law was trying to address was actually quite noble, and that is that we are trying to ensure that with government losing out on revenue, that particular reduction in VAT must be passed on to the consumer. In any case, the law provides for the fact that even if you wish not to pay the penalty, you actually have the ability to go to the magistrate's court and to actually have a trial. You go through a particular process. You can challenge the penalty notice. But what this company sought to do was to go to the High Court and seek a redress saying that I am already presumed to be guilty and therefore my constitutional rights have been breached. So the magistrate said no, the High Court judge said no. If you wanted to challenge it, you can go to the magistrate's court. The judiciary is independent and you will get a fair trial, so where is the breach? The fact that you were given a notice and a penalty notice to pay the fine is not in any way a breach of your constitutional rights, to put it simply. So that, I think, is very important. So please be aware of notices that comes from FERCA. There are, of course, other areas that you can always talk to them about. But in strict liability cases where there is a very simple requirement to adhere to the law, we must be able to do that.